Hi everyone, my name is ATTY Frekhtman. I'm a New York City personal injury trial lawyer. And today I wanted to talk about what happens when you get a motion to dismiss, a motion for summary judgment. Defense lawyers love these and insurance companies love them too because they can get your case dismissed, thrown in the garbage and completely gone. And you cannot recover a penny. But find out what the law is and how a plaintiff who's bringing a personal injury lawsuit can withstand a motion for summary judgment. Well, today I wanted to talk about the burden of proof, and this is what the defendants have to prove in order to meet their initial burden. A motion for summary judgment basically takes the place of a trial, because if it's granted, you won't be able to go to trial. And so the defendants have to prove that there are no issues of fact for a jury to decide. In law, the jury is the fact finder. Their job is to find the facts, to make decisions about what happened. The judge is there to preserve the law. So when they file a motion for summary judgment, what the defendants have to show is that as a matter of law, there can be no way that any juror can ever find any issue of fact. So for example, in a slip and fall case, what they would have to show is that if somebody says, I slipped and fell and there was a puddle of water, what they would have to show to meet their initial burden on summary judgment is to say, we went to the place where the incident happened. We looked at it, the floor. Let's say it was a store. We went to the store. We looked at the floor. We were there half an hour before the fall. The floor was clean. There was no water there. It was pristine. It was beautiful. There was nothing wrong with it. We didn't know anything about any water. And now, the plaintiff says later that they fell, but they could not have fallen there. Now they've established their prima facie burden that as a matter of law, there could not have been any water because they have evidence that they were there recently before the incident. They looked at it and there was no water. So that shifts the burden to the plaintiff. And now the plaintiff has to come forward and say that when I fell, I slipped on water, I took a look to see what was there, and I saw water, plus, maybe I have a witness that was there in the store earlier who saw the water there an hour before. Now that raises an issue of fact, right? Because the defendants are saying there was no water, you're saying there was water. So now you can't decide summary judgment. Summary judgment is only granted when there are no issues of fact. But sometimes the defendants can win on summary judgment if they, for example, in that same situation, if they can show that I inspected, I work for the supermarket, the store, I walked the floor just 5 minutes before, here's my checklist, and there was no water, and then the plaintiff isn't sure. They say, I don't know what I fell on. Well, now they could dismiss the case because the plaintiff doesn't know what happened. The defendants are saying as a matter of law, there was nothing there. So those are the kind of things that you have to look out for and to beat summary judgment. It's also important to note that a lot can be done by a plaintiff just in attacking the initial burden that the defendant has. Like, for example, in that slip and fall case, the defendant has to examine the area shortly before the time of the accident to show that there was nothing here. If the defendant just talks about their general procedures, that usually I do X or usually I do Y, there's case law from the Second Department Appellate Division in New York holding that just evidence of custom and practice is not enough to maintain your initial burden. So they would deny the summary judgment motion without even looking at plaintiff's proof. So that initial burden by the defendants is pretty heavy. But you have to know the case law and you have to be able to really attack it in your opposition papers so the judge sees the precedents that you're applying and sides with you and denies the motion. It's a very dangerous motion because, like I said, it gets the case dismissed, but there are ways to fight it. I hope this has been helpful. Let us know if you have any questions, and we're here for you. Have a great day. Bye-bye.